And you are live, Your Worship.
All right, thank you very much, Sarah. All right, members of council and members of the public that are joining us, this is a council meeting for 3 o'clock today of the Township of Clearview, 3 o'clock here on Monday, December the 7th, 2020. So we're all present. We have our clerk, and so we will call the meeting to order. Item number 1 is the approval of the agenda. A recommendation be it resolved that council of the Township of Clearview hereby approve the agenda dated December the 7th, 2020. Is there any amendments or agendas? Okay, I'll look for Mr. Walker to move that, and I'll look for Mr. Broderick, who's seconding it. Is there any questions on the agenda, members of council? Seeing none, I'll call the motion. All those in favor? All right, the agenda is approved. Item 2 is disclosure of pecuniary interest and general nature thereof. Is there any disclosures from members at this time? Seeing none, if anything comes up, please bring it forward and we'll deal with it at that time. And then item number 3 is our Director of Legislative Services, our clerk, Madam Pam Fettis. Pam, if you're with us, please join us, and we'll have a presentation by our clerk. I don't see her online right now. Mr. Sage, would you join us for a moment? And we'll just confirm that we are going to have a presentation from the clerk. I think she's going to be joining us. Is that right?
I believe so, Your Worship.
Yes, I know she was here a moment ago, and now she has disappeared. Perhaps there was a problem there with the way the meeting started. I know that Sarah had a conflict with her computer.
Yeah.
So between Sarah and Pam, they may have conflicted each other on their computer logins. So hopefully that gets straightened away.
So Sarah, if you're there, you need to let Pam log on.
Yeah, that's what's going on there. One of them had to log out to let the other one in.
Yes, sir.
Okay. All right, well, we'll stand by for just a moment then, and we'll wait for Pam to join us.
So we've had a few staff members get booted. Brenda, I know you can probably hear me. As Clearview Clerks, that should be Pam, correct?
I believe Clearview Clerks is Sarah right now. And that's why I think there might be a conflict in the fact that the two of them are logged in at the same name. All right?
Correct.
Yeah.
If you can hear us, Sarah, I assume you're getting the chat messages from Pam.
Oh, hello, Your Worship. Can you hear me?
Yes, Ms. Fettis. Welcome back to the meeting.
Thank you.
I was just explaining that I think there was a conflict in the logins just a minute ago. So I'm
There
glad
was-
to see that you're able to join us.
Sorry, just bear with me for one moment here. There we go. We're back.
Oh,
Hello, everyone.
the clerk has joined us. Nice to see you, madam.
Sorry about that, everyone. Sometimes technology works well, and other times we need a little bit of help. So thank you for bearing with us today. So your worship and members of council, it's my pleasure to provide you with a presentation that has been created by a group of Simcoe County clerks. And we've entitled it Time for Change. And this refers to the Municipal Freedom of Information and Protection of Privacy Act. So certainly we've had a lot of discussion about it in the past, and it is 30 years old. So we think that it is time for change, and thus the title of the presentation. So without further ado, I will continue on here. So with me on the committee, we have several Simcoe County clerks. We have John Daly, who's the Director of Statutory Services Clerk for the County of Simcoe. Myself, Dina Lundy, who is the Director of Legislative Services Clerk for the Town of Waseca Beach. And we did have to change the title a little bit of our group to Simcoe Muskoka because Karen Way moved municipalities and now she's up in the Muskokas. So Karen Way is the clerk for the Township of Georgian Bay. So how did we get here? How did we form a committee? So the first thing we did is we met informally, and we noticed that we had similar issues with the legislation, and we wanted to work through those. So rather than be reactive, we wanted to be proactive and, maybe talk about what some recommendations for change could be should this legislation be reviewed. But the first thing we wanted to do was meet with the IPC senior management team. So last summer we met with the IPC senior management team. So I guess it was 2 summers ago now. We went downtown and we met with the team down there. And even though we've had a lot of challenges with some of the decisions that have come out of the IPC office, we wanted to know what their challenges were and their successes are. And they're actually doing quite a great job at managing the caseload. But just like us, they're having some challenges too. So the next thing we did is we decided we were going to form a committee with Simcoe County clerks and really steer some recommendations forward to direct those to the province to see if there was any appetite to review the legislation. We have had some successes. So after about a year of work and researching different best practices, etc., and talking about what some of our mutual concerns and recommendations were, we were able to put together this presentation and present it to the Minister of Government and Consumer Services. And his worship was there, as well as all members of our team. And our MPP, Jim Wilson, also joined that discussion. And I think it was very well received by the Minister of Government and Consumer Services. And maybe at the end, his worship can comment on that meeting. So we've also made several presentations to different organizations. And the first one that is important is going to our own association. So clerks and treasurers have their own association. And we made a presentation to the AMCTO Legislative and Policy Committee. What we are doing right now is we're going around the province, and it's actually good for us, working in our favor that everything is virtual these days, because we're able to make this presentation to several clerks groups in Ontario, and certainly it has been well received and something that everybody has expressed there's a need to change this legislation. And finally, we're helping to reach other stakeholder groups as well too. So we're helping to reach out to the Minister of Municipal Affairs and Housing, as well as to AMO to present to them what our findings have been. So our group really focused on several key parts of the legislation. So the first is administrative. The second is routine disclosure. The third is frivolous and/or vexatious, which you've probably heard the most about. Cost to the taxpayers, shared experiences, and just wrapping it up with it is a time for change. So starting with administrative efficiencies. So this act was created 30 years ago, and there hasn't been any substantial changes to it. So we really feel that it's a time to take a look at this legislation. Certainly technology has changed, as well as public expectations on what's available and what is not available. So it's really an opportunity to look at revamping the legislation to reflect more up-to-date practices. As an example, some of the legislation still refers to floppy disks. And as we know, floppy disks, you can't even find a computer to put one into anymore. So, it really just speaks to the age of the legislation and particularly why it's important to look at it. But the other important thing is globalization and privacy concerns. With the internet, privacy concerns are now really globalized, and we need a legislation that primarily focuses in on that. So these are just some standard things that as clerks like to focus on because we're all about the paperwork. So really what we're saying is the IPC forms need to be updated. So this really speaks to the age of the legislation and how things have evolved over 30 years. So what some of you may not know is that the IPC forms don't even include an email address on them. So think about how long we've been using email, and then you can start to think back to how old some of these forms may actually be. The other thing that we think is really important is that when people file an FOI request, there are some fees and charges we can charge to the requesters. And we think it's really important that those requests be put front and center when people are filling out their requests. So there's no surprises for the requester when the institution does ask for some payment for searches, etc. What we're also saying is that we would like there to be a requirement to fill out the institution's designated form. Sometimes requesters will submit their own form, or they'll submit a request in a letter, a standardized letter template, that sort of thing. And oftentimes there's information missing. So it would be really helpful if there was a requirement to fill out the institution's form. And we'd also like for communication methods to be updated between all parties. So right now, the IPC office is stating that the fax machine is the most secure form of communication. And, back 30 years ago, the fax machine was the primary source of communication. But now, as we all know, email and other encrypted forms of communication are taking precedence. So we really think that it's time to update that model as well, too. So again, these are some administrative things, but what would be really helpful for us as administrators is if there was a portal. Oftentimes, appeals can take up to several years to resolve, and oftentimes, just like in the municipal world, staff are transitional, and sometimes they retire, or sometimes they get promoted, or they move to another position. So oftentimes the file changes hands within the IPC office. So this would be a simple way where there would be no personal information that would be presented, but we could find out what the status is of the appeal file and also who's been assigned to it. And this would provide some greater flexibility in understanding the process and the status of the files. So the head under the Act, so currently the clerk is the clerk is responsible for all corporate records under the Municipal Act. But under the Municipal Freedom of Information and Protection of Privacy Act, the head is counsel unless they have delegated it to an officer. And in our experience, and in speaking to a number of clerks across Ontario, almost all municipalities have the clerk designated as the head. for the primary reason that they are responsible for all the corporate records. So we think it's time to adjust that in the legislation as well too. And what we found is in our research and looking at other jurisdictions such as PEI in Nova Scotia, the head already rests with officers of the corporation rather than at the political level. So this is something, the Stakeholder Advisory Committee, so this is something that the province of British Columbia has implemented, and we think it's actually a really great idea to implement in the province of Ontario. So what they do in the province of British Columbia is they have an advisory board committee that represents different interest groups. So certainly we would ask for a municipal representative to be there, but also there could be a lobbyist group, there could be somebody from the media, etc. And just to really speak about the trends and boots on the ground approaches that are working and maybe some things that the IPC office needs to address through future decisions that may be occurring. And it's something that works really, really well in British Columbia. And certainly we think it's time for something like that to be championed in the province of Ontario. Obviously, the benefits, it would offer different perspectives. So from all stakeholders, it would offer their perspectives. And also, you know, the representatives of that committee could also act as ambassadors between all parties. So routine disclosure. So every municipality, including ours, has a routine disclosure policy, or they can have a routine disclosure policy, but they're all a little slightly different. And a routine disclosure policy is basically a document that says we're going to release these types of documents without having to go through an FOI process. And we feel that it's time for all municipalities in Ontario to have that routine disclosure policy in place. And what we're recommending is we're encouraging the IPC office to work with AIM-CTO, who's our association, to develop a template of a routine disclosure policy based on shared collective experience between both offices. So every day there's decisions being made on what documents can and cannot be released. And we think that having a template would definitely be beneficial to all clerks in Ontario, but also it would be extremely beneficial to residents and requesters in Ontario, because it would create a document where FOIs would not be required and that they could access that information freely. And what our group truly believes is that whether you're going to the County of Simcoe, the Town of Wasaga Beach, the Township of Georgian Bay, or the Township of Clearview, and you put in the same request, your request should be treated the exact same. And right now, unfortunately, it's most likely not being treated the same all across Ontario, and we feel that needs to change. So that's something that we can do better, and we just need some help to get to that point. So frivolous and/or vexatious request. So this is something when our group sat down, we looked at it, and it's really a pretty big topic, and it includes a lot of things. So we broke it down into 3 different areas that we wanted to look at as a group. Certainly it could be expanded to a bigger area, but for the purposes of this presentation and our recommendations, we focused on three elements that were common in all of our municipalities. So the first is the threshold. So I'm just gonna move you just down here a little bit. Okay, so the threshold. So the threshold used to establish frivolous and/or vexatious is set out in M850 and MO2488. So those are just the case numbers. And in the last case, the requester, so this is the threshold that they use to determine if somebody is frivolous or vexatious. In the last case, the requester sent over 300 emails. So think about that. Think about 300 emails from one person in your inbox in a 6-month period, in addition to submitting 54 requests with 372 parts over a 2-year period. So just think about that. Think about somebody sending 300 emails to you within a 6-month period, in addition to submitting 54 requests to you with 372 parts over a 2-year period. You're quickly going to become overwhelmed, and that's going to be your focus if you're required to respond to it. And this was a requester from the city of Vaughan. So with this case, the IPC office said this is the benchmark for frivolous and vexatious. But as you can imagine, requests similar in scope, even by division of 1/2 or 1/3, would place a substantial strain or hardship on municipal operations. So the city of Vaughan, they have people that all they deal with is FOIs. That's all they deal with. And what we're saying is that, in smaller municipalities especially, even by division of 1/3 or 1/2, this is going to create undue stress and pressure on municipal operations and allowing us to get our work done that we need to get done. But it also disadvantages other requesters and other people's access to the clerk's office during that time when you're dealing with these requests. So what we're suggesting is there needs to be a new reasonable threshold based on municipal legislative framework. So we feel this is too high. We simply need something that's a little bit less to meet. The second part we looked at with frivolous and or vexatious was the appeal process. And in Ontario, when a request is deemed frivolous or vexatious, the municipality is required to provide reasons for this designation. So somebody asked for, why are all the roads painted green, or why are all the roads painted black? We might say that's frivolous and or vexatious. And we have to provide them reasons why we think it is such. And it's up to them whether or not they want to appeal that decision to the IPC office. And obviously, the one thing that I always hear often is, well, why do you even respond to those? Like, just don't respond to them. Like, it's not worth it. I mean, obviously, they're just trying to waste your time. Why respond to it? And the important thing is to notice that this is a statutory process. So if you do not respond to an FOI and it's appealed, it's considered a deemed refusal. And the IPC office will order you to respond to that FOI. So you really don't have a choice. You do need to respond to it. But what we found through our research is that in Alberta, Newfoundland, and Quebec, they have a little bit of a different process. So what can happen is that the public body, meaning the municipality, we can actually go to the IPC office before we respond to the requester and say, listen, we think this is frivolous and vexatious. What do you think? And that would be really helpful for us, because once it gets to the appeal process, it's quite labor intensive and costly to all taxpayers. So having that step in place where we can actually go to them instead of waiting for the appellant to appeal would be really helpful to both the municipality and the appellant, because then it's a straightforward answer as to what we need to do with those documents and that request. So then we have our third component, which is frivolous and or vexatious, and it deals with harassment. So unfortunately, we do have some requesters in Ontario that do use this process as a way to harass employees' performance. Because it's a statutory right that somebody can submit an FOI and the municipality is required to respond to it. Unfortunately, we do have some people that use it as a way to harass employees' performances. And what we're finding is that in a lot of these requests that are being filed across Ontario, the language that's being used in them is deplorable and is contradicting anti-harassment and safe workplace legislation. So that's where we really feel that there needs to be a review of NFIPA and to look at how it's matching up with these other pieces of legislation that the province has asked us to have in place. Because oftentimes the municipality needs to make a decision to either support the staff person or process the request. And that's not a fair position for anybody to be in. So we really feel that that needs to change, and the province needs to take a look at that. So cost to the taxpayers. So on the left-hand side of the screen, these are the steps that are required for a clerk to take when there's an FOI that's delivered. So this is why the routine disclosure policies are really important, because if we don't have to go through all these steps, we don't want to. Because first of all, we want to make as much of our records available to the public as possible for transparency reasons, but also it's very labor intensive every time there's a request that is submitted. This does not involve any notification for third parties. So if the file affects a third party, we have to notify them. So those steps are not included in this. And it also doesn't include the appeal process. So I want you to look at the right-hand side of the screen. And the only difference is the ones that are highlighted in green. And those are the ones that we can charge for. So think about that. There's, I don't know, there's 9 steps there and only 2 you can charge for. And the costs that can be charged are very, very minimal. So what this means is that taxpayers are ultimately subsidizing the cost for this program. And here's some of the fees and charges, unaccounted for fees and charges. So the length of process and closure of files. So oftentimes these files can be open for several years. And, as long as the files are open, they're costing taxpayers substantial amounts of money. Sometimes the IPC office, after we've searched for records, they'll come back and they'll say, you need to do a second, third, fourth search and swear affidavits. And every time we have to do an additional search, we cannot charge for that. So that is something that's taking up clerk's office time and effort, and we're not able to collect any further money from the requester. And this is especially important if they change or modify the request during the appeal process with the IPC office. We cannot go back and ask them for additional funds. Obviously, the allocation of staff time to deal with these requests, the legal fees, oftentimes they're getting very complex, or sometimes when they're harassing in nature, we need to reach out to lawyers to help us to mitigate those risks. Here's one that is becoming a trend in Ontario, and it's something that we feel the province really needs to discuss and deal with. We're getting requests from people or lawyers requesting access to our files before it goes to court. So if there is going to be a civil action, a lot of times people or lawyers will file an FOI and ask us for the information prior to making a decision whether or not it's going to go to court. So they're asking us to show our hand before they enter into the court process. And as we all know, anytime that there's civil action involving the municipality, it's ultimately the taxpayer that is paying for that. As well as the limited fee structure. So I mentioned that the costs are very small that we can charge back to requesters, which there are 2 sides to that. But what ends up happening ultimately is that the local taxpayer is subsidizing the cost for all of those requests. And we're going to talk about a few examples in the future. So this part of the presentation is where we usually get the most comments about after our presentation to the different associations. And these are real life examples that have happened in municipalities. So the first thing I'm going to talk about is the length of time to resolve appeals. So we have a case in Clearview. It's MA 15632, and it concerns a contentious and heavily litigated matter in the municipality. It's been on the books since 2015. So we're almost at the end of 2020, and this is still ongoing. So just think about that. Almost 6 years now working on the same file. I would suggest between staff time, resources, and legal expenses, the municipality has spent over $25,000. So just think about that, $25,000. And you're going through budget right now, so think about what $25,000 can buy you. Through the IPC Regulation 823 and their fees and charges that we're able to collect, we were only able to collect just over $1,000. So what that means is the taxpayers are subsidizing the cost difference between those two things. This appeal is yet to be resolved, and no further fees can be collected through the appeal process. So here's an example of a frivolous and/or vexatious requester. So in Clearview, we've had one requester that has asked for 790 items since 2011 through the FOI process. And there's the numbers there. In these requests, they use colorful language to provide their opinion of staff's intelligence, competency, professionalism, and integrity. States there will be legal repercussions if we don't do the following. Has accused one of our staff of using his snowplow as a weapon. In one FOI, went to the staff directory and listed everyone from the CAO to the Public Works employees requesting their Law Society of Upper Canada registration number. So just think about that and think about the time and effort from looking at all of the different steps that are involved in responding to a request, and think about how much time it costs to go through this request and to submit an answer to the requester, and how much that would have cost taxpayers. And I would suggest, I'm not sure how relevant it is to know if, you know, everyone on staff has a law degree. This requester has also submitted costs for his time and effort to put together FOIs to submit, and follow-up course from request to staff, council meeting, etc. Suggests further complaints will be filed or have been filed with the Attorney General, OPP, Minister of Municipal Affairs, etc. for privacy issues and/or breaches he alleges occurred by myself or other staff or council members. And with this requester, when you say no, you usually get comments like this that are coming back to you. Sadly, I have to tell you, Council, that from doing these presentations across Ontario, we are not alone. And there are a number of clerks and members of council out there that are being harassed by residents that are using the FOI process as a way to belittle and to intimidate members of staff and members of council. And it's something that needs to be addressed. So we've also had an issue where we have had a request for somebody wanting a copy of the procedure, or wanting a copy of the procedural bylaw, not a copy of the procedure bylaw. And it's one of those things you kind of get, and you just kind of say, okay, well, you know, it's the same document. So what we did is we explained that it's the same document to the requester. We provided examples of how the term is used interchangeably. So we went to different municipalities. Now think again about the cost to taxpayers. So we went to different municipalities and we showed how some municipalities, you call it the procedural bylaw, others call it the procedure bylaw, showing how it's used interchangeably. The appellant, the requester who then became the appellant, I was able to find an email from this appellant where they actually called it the procedural bylaw and quoted sections from it. So they obviously knew the difference between the procedure and procedural, that there was no difference. They were able to find an email from me where I said that we were reviewing the procedural bylaw, and they would be able to provide their comments at that time. And as a result of that, it did not meet the frivolous and/or vexatious request, the threshold for frivolous or vexatious with the IPC office. So, you kind of get to a situation where like, okay, well, it's not frivolous or vexatious, but the procedure bylaw and procedural bylaw are still the same document. So what we ended up doing was just sending a copy of the procedure bylaw to that appellant and saying, here you go. But that appeal itself took over 2 years. It took over 2 years to resolve with the IPC office. So just think about that and think about the staff time that's involved in that process. This is something that happened to a colleague of mine, and so there are other municipalities that are struggling with similar issues, but different issues as well too. I can tell you that this is a young clerk that has a young family, so she has little kids, and this was something that was very concerning to her. So sometimes, when we're working, sometimes when we have to say no to people, they take it very personally. And with this appellant, they took it extremely personally and were relentless in their pursuit of the clerk. And the appellant conducted a substantial background check on this clerk. And in that background check, they had included information that was not easily obtainable by a Google search. She feels that they hired a private investigator to investigate her. And I can tell you that's a really scary situation for any employee, that somebody who is relentlessly pursuing you because you told them no is now having you, personally investigated by a private investigator. The length that some people are going to, it's really alarming. The appellant in this case submitted the background information to the IPC office and they accepted it. And as a result, when the clerk received a copy of it, much of it was inaccurate. And to defend the integrity of that, which was the clerk, the municipality had to hire legal counsel, at the expense of other taxpayers to defend the clerk and the integrity of their position as the head of MFIPA to the IPC office. And this young clerk, she says this happened around Christmas time. She had her kids in the car. They were driving to Christmas dinner at her in-laws. And she's on the phone with the lawyer trying to sort out this mess because the IPC office has accepted inaccurate information that could affect the appeal process. And certainly that's not something that any municipal professional should have to go through. The appellant decision to close the file. So through the appeal process, it goes through a couple different stages. So the first one is the intake. So the IPC office looks at the file and they decide whether the appeal is going to be carried forward or not. And they have their own set of parameters. And when we talk to the senior management team at the IPC office, they shared with us their statistics, and they actually do a really good job at stopping some of the appeals from going forward. But there are several that go forward through the process. So the next step is mediation. And through mediation, even if the IPC office disagrees with it going forward to adjudication, if the appellant feels that it needs to go to adjudication, it automatically goes there. So think about that. Even if it's something that the IPC office does not feel should go to adjudication, if the appellant feels that it needs to go to adjudication, it automatically goes there. So that's what's causing a lot of time and energy with some of these appeals that are ongoing at the IPC office. So there was a case where there was an appeal filed. The municipality has done 3 searches. They had to re-verify the list of documents 3 different times, and there was no cost recovery. And that clerk estimated that each time they had to do a search, it took between 10 and 15 hours. So you can do the math, and that's about 1 week of somebody's yearly yearly salary with the municipality that they're spending on one appeal. And that doesn't include the interactions with the IPC office or the correspondence that's needed, anything like that. That is just to do the searches. So here's another interesting example that happened in a local municipality in Simcoe County. So there was a request for design of a house of another resident. And this might pique your interest because I believe that it was an elected official's residence. And the clerk denied the request based on security of the property. So basically what happened is, so we'll use the mayor as an example. So somebody comes and they ask for the mayor's house drawings. And I'm not allowed to tell the mayor who's asking for his house drawings. So obviously, in this case, the person said, no, I don't want my house drawings released because I don't know who's asking for them. So the requester appealed the decision to the IPC office, and the IPC office ordered them to be released because there was no immediate or known threat to releasing the floor plans of the house because there was no written threats, but there was a history of conflict and confrontation between the two parties. So just think about this for a moment. You know, it could be any one of us. So, you know, in situations, you have to tell people no, people disagree with you, and not everybody likes you. All of a sudden, you're asked for the house drawings of your property, and you're not allowed to know who's asking for them. And all of a sudden, you know, the IPC office is ordering that they're going to be released. And, you know, in this circumstance, this person had a history of conflict with another member of the community. And, you know, he was very nervous about this person having, you know, floor plans and drawings of his house, knowing where he sleeps, where his kids are sleeping, you know, points of entry into his home, etc. And the clerk could not tell the person whose house drawings were asked for who the request was from. So we really feel that that needs to change because not everything can be imaginary and fanciful. We never would have expected that in 2020 we would be going through a health pandemic where everybody's wearing masks. But it did happen. And what we're saying is we always hope that nothing's going to happen if we're told we have to release house drawings, but we don't know. So we would like to not to be in a position where we have to make that decision. So we have some further considerations that just didn't really fit into any of the other boxes that we talked about today. So we really feel that as a group, the requester name should be public when asking for general records to match other legislation. So when you come before council for a planning public meeting, as an example, you have to state your name for the record. We really feel that, you know, requesters' names should be made available to the public. We also feel that any decisions that are being made out of the IPC office with regards to other legislation should be sent to that ministry to make changes to their legislation if appropriate, just so that it matches all across the board. And then the last point is, if a record has been destroyed in accordance with the retention policies, we should not have to be required to do additional searches of servers, etc., for the record. So we really feel as a group that it's the time for change. The legislation has been in existence for 30 years, and certainly other privacy legislation is getting a refresh and a reboot, so to speak. And we feel it's time for this piece of legislation to also have a review at the provincial level to see how it can be updated and changed to fit current priorities, but also think about the future and what future privacy concerns may look like and adjust the legislation accordingly. And As I said earlier, we are reaching out to local clerks groups. The presentation's been very well received. Certainly Clearview is not alone in dealing with these issues. Some of them are unique to us, and others are common throughout all of Ontario. And just like us, when we have unique issues, other municipalities also have unique issues. So, but it is something that clerks across Ontario are saying it's time for a change. And I think requesters across Ontario too are saying it's time for a change. We need to look at opening some things up a little bit more freely as well too. So certainly we are asking our peers and colleagues to write their support into Ministry of Government and Consumer Services, Ministry of Municipal Affairs, Ministry of Attorney General, AMO, and AMCTO. And, you know, this is the kind of a slide that says when change happens, when enough people speak up with the same voice. So, you know, I would encourage anyone, whether or not you agree with the recommendations that Simcoe County clerks have put forward, hopefully you will agree that it is time for a reboot and a refresh of this legislation. And it's really important to speak up and to share your thoughts and opinions with the province regarding this issue. So that's our group 10, and Your Worship, that concludes my presentation. I'd be happy to answer any questions.
Great. Thank you very much, Pam. It's the third time that I've seen the presentation, and it always shocks me some of the material that's in there that actually happens in the work that you do and your colleagues do. So I thank you for your work that you do to represent the interests of taxpayers. So thank you for that. Members of council, do you have any questions on the presentation that our clerk has given to us? Looking for any members? Mr. McKechnie, I see, and Mr. Patterson. Go ahead, Mr. McKechnie, and then Deneen. Go ahead.
Thank you, Your Worship. Pam, if I'm getting into any sensitive area here, just feel free to say that you can't answer. But first of all, you know, reading through your looking through your presentation and listening to you makes one wonder why anyone would want to get into public service, whether it's at an elected level or a staff level, you know. But anyway, you mentioned the one item that it's cost $25,000 so far. Any idea what it's costing this municipality annually to in legal fees and staff costs to deal with freedom of information items? Are you allowed to divulge that at all, or is that privileged confidential information?
Mr. McKechnie, I think we'll go to Pam as well as the CAO on this very item. So go ahead, Pam, first, and then I'm sure Steve, our CAO, would like to comment. Go ahead, Pam.
I actually saw the CAO pop up, so I might defer this to him.
All right, we'll go directly over to the CAO. Mr. CAO, do you have a comment about our expenses, staff time, and or legal expenses?
So, Your Worship, unfortunately, we do not track our staff time specific to the FOIs. As Pam alluded to, there are some items that we can charge staff time for, but it's an extremely small percentage of the overall cost. But I can assure you that we have had spikes in legal costs with this item as high as $75,000 annually. We had one year was over 100, but we're averaging in the $45,000 to $55,000 a year in legal fees. So not including staff time, which is probably significantly more.
Thank you, Mr. CAO. Mr. McKechnie, you comfortable with that information?
Yeah, I mean, that's a shocking number. I mean, 45, 50,000 just in legal fees, and it's probably double that when you look at staff time, I would think anyway. So yeah, I'm happy with that. That we could sure use that money in a lot of other places. Thank you.
Thank you. That's a good point. Thank you very much. Okay, Mr. Yes, go ahead, Pam.
Oh, sorry. I was just going to say, if I can make a comment. One of the issues that I struggle with personally is some of our requesters do not even live in Clearview Township. So that means that 100% of the costs are being subsidized by the local taxpayer and not by the requester.
Yeah. And you made the point earlier in your presentation that many of these requesters could be or may be legal firms that are simply doing research, and we're taxpayers are supporting it. So there you go. Okay, I have Councillor Patterson and then Councillor Deneen. Go ahead, Councillor Patterson.
Thank you. Yeah, certainly appreciate the effort and the need to look to reforms on FIPA. But just to follow up on Councillor McKechnie's comments, would it be fair to say that the costs that are outlined by the CIO are not fairly distributed over many of our residents? They tend to be one or two or three. The reason I ask that question is, sometimes we can take measures on something that works administratively well. I'm not suggesting that FIPA is right now, but and we might have to we wouldn't do reforms across the province if it was for a very small group. But the people that you've been talking to, they generally can point to a broad problem with FIPA across their residents, or does it tend to be focused on one, two, or three people in the municipalities you've talked about?
Let's go straight to Pam with that. So Pam, is it just one or two in every municipality, or is it equally across all municipalities that have similar problems?
Yeah, so I can tell you, Councillor Patterson, that municipalities get all sorts of different types of requests, and some requests are a little bit more contentious than others are. Some of them are pretty straightforward and can be handled internally, while others need a little bit more attention. And sometimes in that case, we do need to rely on legal to help us, formulate answers and to make sure that we're doing everything correctly. I'm not going to say whether it's one or two, because in my experience, there's multiple factors every year. So some years, we get a lot from lawyers as an example, and other years we just don't. So anytime that, we feel that there could be a future lawsuit in play, as an example, we do need to reach out to legal counsel, because we need to protect the corporation. That's part of our position here. Part of all of our positions here is to make sure that the corporation is protected. Certainly the requesters that are submitting multiple requests, sometimes they are straightforward and we can answer them without going to legal, and other times they cross lines, like that example of the young clerk that I talked about, where she was privately investigated. And all of a sudden, the municipality now had to hire legal representation to defend her with the IPC office. So certainly, we have cases similar to that too. And it's really kind of a mixed bag across the whole spectrum, but certainly some requesters, we do need to spend a little bit more legal resources than others, if at any.
Thank you. Mr. Patterson, are you good?
Yeah, the reason I asked that fine point was because my main question is the sensitivity of the province to this issue and the likely receptiveness of the province to doing something about it. I noted you met with the Minister of Government and Consumer Services. Is this a program you think that will find a home in legislative changes in our current government, or are we trying to push hard to open this process?
Let me jump in there first, Tom, and advise you that yes, I did sit in with the clerk with a meeting with Minister Thompson, and yes, her ministry, many staff of her ministry were on the call, and they showed great interest and understanding of the problem, simply because we're one municipality of many that they have heard from about this very issue. So it's to the credit of our Simcoe County group and Muskoka as well, who have formed this group together and made these presentations. So I'm very thankful that some of our professional clerks are stepping forward and bringing this to the attention of the government, and they are getting some feedback. Ms. Fettis, do you have any comment?
Yeah, so I can tell you, Councillor Patterson, that this is on their radar, but I'm not sure if it's front and center. And we need to collectively have a strong voice to say this is something that needs to be addressed, because, you know, we kind of tend to focus on our experience as the municipality in dealing with this, but requesters also have the same level of frustration in dealing with the requests as well too. So it's something that's all encompassing, and it's something that we need to have a wholesome discussion to really have a strong piece of legislation moving forward. Certainly we have issues that we would like to see dealt with, but other stakeholders probably have other issues as well too. So it's something that I would encourage members of council to speak up and to say, we need to solve this problem. We need to solve it for a number of reasons, and that includes for all of our stakeholders. I can tell you that I sit on the AMCTO Policy and Legislative Committee, and it's something that all members, there's about 13 of us from all over Ontario, representing large and small communities, and it's something that's on our radar. I understand it's on the City of Toronto's radar. So it is getting out there, but, you know, we need everybody to collectively stand up and say, you know, we need to review this, and we need to review this shortly.
Thank you. All right, Tom, we're comfortable. We'll go to our next counselor. Thank you. Mr. Sage is there and to also answer questions. Counselor Deneen is next, and then Counselor Leishman. Go ahead, fellas.
It's just a little bit more, just not so technical, but I just wanted to say thank you, Pam. That was really well presented. And every time I had a question pop into my head, you subsequently answered it before I even could write it down here to ask. And just that I'm really sorry that yourself and other clerks have had to endure this type of problem. And after 30 years, you definitely have my support to remedy this antiquated procedure. So good for you and the other members of your team. Thanks.
Very good. Thank you for that. Councillor Leishman is next.
Thank you. Yes, I certainly support what you and your colleagues are doing, Pam. You're saying in your presentation you want us to write letters. I think maybe 9 letters from council wouldn't be a bad idea, just to help support what you're doing. So thank you for doing this, because I know it's been quite arduous, and not just our municipality, but I know other municipalities are having the same concerns. So thanks for doing this. I know it's taking a while, but you'll get there. I know you will. Thank you.
Great, thank you, Councillor Leishman. Any other members of council with wishing to? Oh, Mr. McKechnie is back. I see you there. I'm just looking for anybody else. Okay, go ahead, Doug.
One quick question. Are the volunteers that we have, the committee volunteers, are they impacted by Freedom of Information requests as well? Or can they be impacted by Freedom of Information requests?
Over to Pam. Go ahead, Pam.
Yes, they can, Councillor McKechnie. So we have had some requests that have focused on some of our board activities and asking for emails, etc., from our volunteers as well too. So because they are volunteering with our corporation, they are impacted by this legislation.
All right. Mr. Sage, go ahead.
Yeah, if I could, Pam, excellent presentation. It's the first time I've seen it, so well done. I have a little bit of a question about convincing, or your take on convincing the province to take action. So very early on in your presentation, we mentioned third party. Has there been, to your knowledge, any cases where the private sector has been affected enough that they would become, to Councillor Leishman's point, a letter writer? Because to convince the politicians to make changes, if it affected the private sector as well, that'd be helpful. Just asking.
Interesting question. Go ahead, Pam.
So I can't think of anything off the top of my head, but actually I can. The insurance company. So when lawyers are asking for records or is asking for records in order to determine whether or not they're going to sue us, we do not consult with our insurance company before we release them, because we can't predispose what they're going to use those records for. So when somebody submits a request, we can't thing about what they're asking for. We just have to look at the legislation and see if it meets the threshold to release them or not. And in some cases, we have a hunch that they're probably going to use them to, ensue legal action against us, but we don't know for sure. So I would say that it does affect the insurance company because there could be substantial payouts, because we have exposed our hand before legal action has been instigated, and before lawyers have had a chance to review documents to determine whether or not they should be released to the third party.
Yeah, so I would suggest it would be good if they were writing letters as well. Thank you.
Steve, thank you for that very much. All right, council, anything further on this presentation? All right, Madam Clerk, you have a report with a recommendation that you'd like us to consider. So I'll just put it on the floor. It's LS 018-2020. It's advocacy reform for the MFIPA legislation. It's a pretty extensive report. Is there any questions from council specific to the report? Just seeing. Okay. So members of council, I have a very lengthy motion to read. I will read the entire thing and then I'll ask for a mover and seconder, unless there's any further questions at this time. I'll read the entire motion. I'll look for a mover and seconder, then we can have a brief debate on that. And then we'll carry on with the meeting. Anything further? Okay, so I'm going to read this very lengthy motion, but it's significant. It has a lot of material in it that's.
You're muted.
Your worship, you're muted.
My microphone muted. That's the first time that's happened in a long time. All right. Recommendation, whereas the Municipal Freedom of Information and Privacy Protection and Privacy RSO 1990 MFIPA dates back 30 years. And whereas government operations, public expectations, technologies, and legislation surrounding accountability and transparency have dramatically changed, and MFIPA has not advanced in line with these changes. And whereas the creation and storage, utilization of records has changed significantly, and the municipal clerk of a municipality is responsible for records and information management programs as prescribed in the Municipal Act 2001. And whereas Regulation 823 under MFIPA continues to reference antiquated technology and does not adequately provide for cost recovery, and these financial shortfalls are borne by the municipal taxpayer. And whereas the threshold to establish frivolous and/or vexatious requests is unreasonably high and allows for harassment of staff and members of municipal council and unreasonably affects the operation of the municipality. And whereas the Act fails to recognize how municipal councils, from an individual shortage of staff resources or the expense of producing a record due to its size, number, and physical location, does not allow the time extensions to deliver requests and unreasonable affects the operation of the municipality. And whereas the name, identity of a requester for general records is not required by the Act, permitting anonymous requests, and the name of the requester is not permitted to be disclosed to anyone other than the person processing the access request. And this anonymity is used by requesters to abuse the MFIPA process and does not align with the spirit of openness and transparency embraced by municipalities. And whereas legal professions use MFIPA to gain access to information, launch litigation against institutions where other remedies exist. And whereas there are limited resources to assist administrators or requesters to navigate the legislative process. And whereas reform is needed to address societal and technological changes, in addition to the global privacy concerns and consistency across provincial legislation. Now, therefore, be it resolved that the Township of Clearview requests the Ministry of Government and Consumer Services to review the MFIPA legislation and consider the recommendations as follows. Number one, that MFIPA assign the municipal clerk to or designate to be the head under the Act. Two, that MFIPA be updated to address current and emerging technologies. Three, that MFIPA regulate the need for consistent routine disclosure practices across institutions. And four, that the threshold for frivolous and/or vexatious actions be reviewed and take into consideration the community and available resources in which it is applied. 5, that the threshold for frivolous and/or vexatious also consider the anonymity of the requester, their abusive nature and language in request to ensure protection from harassment as provided in the Occupational Health and Safety Act. And item 6, that the application and scalability of fees be designed to ensure taxpayers are protected from persons abusing the access to information process. Item 7, that the administrative practices implied or required under the Act, including those of the IPC, be reviewed and modernized. And item 8, that the integrity of the Act be maintained to protect personal privacy and transparent governance. Is there a mover and seconder on this motion, please? Mover, Deputy Mayor Burton, seconded by Councillor Leishman. Is there any questions or discussion in regards to this motion as presented? With my one comment, do not ask me to reread it. Members of council, any questions? All right. Yes, go ahead, Tom. Councillor Patterson.
Yeah, thank you. Yeah, I overwhelmingly overriding this, all the details that Pam provided, which are absolutely necessary. I guess my concern is that this will improve the administrative approach to MFIPA and ensure that that vexatious and frivolous claims are kept to a minimum. And I think it's in all our interest that this is not done at the risk of the well-meaning public who are simply looking for more information to understand the decisions we're making. So you're, as you know more than the rest of us, this is a very delicate balance between accountability and transparency, achieving that, and yet taking some of the, I think, the unintended consequences of an old act, bringing it up to speed. So I'll just make one point. I really appreciate the inclusion of a couple of the measures that you've taken. And one is the portal, and the other is the committee. I'm struggling here for the name of the committee that you set up. I think those are positive steps forward. The one question I have on the portal is, because we already have through the IPC some public access to casework, but that's when it gets to an appeal. Are you talking about I'm assuming you're talking about a local portal that would maybe be municipal or perhaps regional or perhaps county? Or are you talking about a provincial portal?
So Councillor Patterson, I'm talking about a portal between municipal staff and the IPC office, because we could have 20 appeals with the IPC office, and sometimes we don't get any action on them for several years. So it's really important that as clerks, we know who has that file and what status it's at, so that we can follow up and to make sure that that appellant is getting answers just like we are for their files. And just to talk about your beginning comments, these recommendations, we've tried to be far-reaching in our recommendations to include things that are both good for requesters and for administrators, but we certainly do agree that there's things that we can do better, as well as there could be better processes for us as well through the legislation. But because we're tied to a 30-year-old piece of legislation, you know, it really ties both our hands, the IPC's hands, and the requester's hands in how we're dealing with requests and appeals, etc. So it's something that's all encompassing and something that we can all do a little bit better at. But with that, we need some legislative changes to make that happen.
All right. Thank you very much, Pam, and thank you, Councillor Patterson, for that good question. Members of council, anything further on this motion as presented? I'm going to add one item, and that is from the report. It did say that we would then distribute this. We would distribute this motion, if carried, to various members around the province, through AMO. and other municipalities. So it's in the bottom of the report. It's not included in the motion, but it is in the report. So that would be the intention to distribute it. All right, members of council, anything further? All right, I'm prepared to call the motion. All those in favor? And that carries unanimously. Thank you very much, Madam Clerk, for that extensive report and good work that you and your committee are doing. All right, council, we're going to move to item number 4, which is our budget public meeting. So our municipal budget public meeting process is commenced at this point. I guess it's quarter after the hour, so we're not really late, but we're scheduled for 4 o'clock, but we're getting to it right now. So members of council, I will call upon our our treasurer and our CAO to outline the results of the budget as well as the council input on the budget. And then we will hear from any members of the public, which I believe we have a delegation or a written delegation to hear from. So let's go to our treasurer, and you can outline for us where we are at the 2020 council proposed budget. Kelly McDonald, nice to see you.
Thank you, Your Worship. Members of council, Your Worship, this is our third viewing of the budget and our third working with senior management. They've done a fantastic job this year. Hasn't been easy. As we left it in the last budget meeting with the additional council changes, we ended up at a 1.8% tax increase, and that's estimated right now. So we have a $513,000 operating increase, $182,000 capital increase, and then we're expecting that to be decreased by about $150,000 worth of growth. And that's where we come down to the 1.8, where we now sit. Unfortunately, we don't have any public delegations, but we did receive a letter from Ms. Jody Pepper, and she is inquiring about having additional sidewalks put in at the east end of County Road 9 in New Lowell, and then also some speed changes made in the township limits as well. I will pass this information on to council. This is the only information received. I'm going to look at that it's good and the public is pleased with our budget.
You're muted, Your Worship.
Oh, sorry about that. This is the first time that's been happening. Just FYI, my computer has been great all along during this process, and suddenly now mine's reacting to this muting that's been going on. Anyway, Mr. CAO, do you have anything you'd like to add to Kelly's presentations?
No, as I indicated previously, I think staff's done a great job on the budget. Staff brought a good budget for council to consider. Today is your presentation to the public. We all have a debate about the residents' lack of participation in our budget public meetings, and I'm not sure any of us know the real reason why that is. It could be negative, it could be positive, I don't know. Keep in mind, council, that there are a few numbers that Kelly does not know yet. So our actual growth numbers are not loaded in. We won't know that obviously till the end of the year. So Kelly and has always taken a conservative approach to that, which is good. And then of course we do not know the school board numbers either. So by spring it'll be a little bit more accurate. But again, I want to thank Kelly. Great budget, great work by everybody, and that's about all I have to say. Thank you, council. Thank you, Your Worship.
Okay. So as I recall, then Kelly, you had only one public delegation, and that was in regards to some sidewalk work. So will that be then forwarded to our staff, and then that will be reported back to us as to provide an answer, or is that something you want? Is that something council should be considering at this time?
I think council should be taking it as the public participation.
Sure.
I don't know that it's something that you necessarily want to debate right now. I think more appropriately, it should go through the Public Works Department. Yeah. And then they can do a little bit of background research for it, just so you have an idea. As I say, it's increasing sidewalks as opposed to our regular maintenance of sidewalks. And then changing speed zones, which I know Dan is working on traffic studies and things like that. So this may be incorporated into there. That would be my course of action.
That'd be great. I think that's a correct way to do that, because the public presentation didn't actually include any dollar numbers or, and so on. So we need to get that information from our professional staff, and that they can present it to members of council for us to consider at our next workshop session. Okay, thank you, Kelly. I saw Councillor Walker gave me a little yellow flash there. Hello, Bob, what's up?
I was just going to say, Your Worship, with regards to the request for the sidewalks, we did increase that sidewalk budget to 200,000, and that was for additional sidewalks throughout the township. So that is something, and I think the work department will certainly review and may put priorities on areas that need it. So I think everything's well within the scope of what we've already set up as far as the additional sidewalks. It was put in the budget to increase that amount of money.
I concur with you. There was some good budget, good discussion about sidewalks. All right, the deputy mayor is there. Remember, this is a public session, so we've already had our opportunity to make input. But if you have any comments on the public session, go ahead. Please go ahead, deputy mayor.
Thank you. You just faded out at the last minute there, by the way, Your Worship. So it sounds like you may still be having ground. Anyways, I did read her email and reviewed it, and my understanding is the sidewalk that's on County Road 9. And if so, that would, maybe the CEO can confirm that. Would it be that's county responsibilities, or do we take care of the sidewalks on the county roads?
All right, so the CAO, Dan Perot, and also I see Councillor Lamers. I'm going to go with Steve first.
Yeah, Your Worship, the sidewalks in New Lowell are 100% responsibility of the Township of Clearview.
There you go. Mr. Perot? Dan Perot, do you concur with that?
Yes, Your Worship, thank you. Just what Kelly said, we'll have to see where this request is coming from. The east side, east out of New Lowell, I'm not sure there's many residents on that stretch there, but we'll have to investigate and report back.
Okay, then that's what this council hopes to have, is a report back. Mr. Lamers, go ahead.
Yes, I was going to ask the same thing as the deputy mayor. We're getting to the outer limits of town, so Dan would have to look to see if it is the county, or even if we have enough road allowance to put this sidewalk down. There's probably about 10 or 15 houses west or east of New Lowell. It's fairly narrow shoulder, and with the snow plows, there's no room to walk to school.
Yeah. Okay, well, we'll definitely get a report back from our staff, and that's something that we can consider at our next budget meeting. So I would ask the staff of Public Works and through the treasurer to make sure that that's included in our next workshop session. All right. Anything further then, Miss McDonald? We're good. You'll have this information available to us at our next workshop, which is, if I'm not mistaken, is that the 13th of January? Is that the date?
Yes, Your Worship. We have that one scheduled on January 13th. It is a Wednesday, so everybody, if you could just kind of put a little reminder there in your calendar that it's not going to be on a Monday night.
Okay, council will have to check that and make sure it's in your calendar on a Wednesday for a workshop session in regards to the budget. All right, I saw, Tom, you had your hand up. Did you have something else to add to the public session?
Well, not for discussion, but just a heads up. We talked about several projects that we have pending work to do that may or may not be included in this year's budget. And as I indicated earlier in our process, I put a report to council going forward to see if we can bring some resolution to some of these projects. There were the four that we've talked about before: expanded police enforcement, small halls, senior and social housing, and Collingwood Street bridges.
Yeah.
So, you can look forward to seeing that item on next meeting, which is on the 14th of December.
Yeah. So just to review those provisional items, Tom, some of them are direction to council that are not going, or to direction to staff that are not going to cost us anything, but they're directing them to actually perform some function to report back for consideration in the 2022 budget, which is specifically the Collingwood Street Bridge discussion. we hope that they would have that included in their engineering discussions so that we can make that decision by 2022. In fact, I expect we'll make the decision in 2021. It'll just be impacted on the 2022 actual taxation budget. So that's one. The OPP information, as far as additional enforcement, we are still waiting for information from the OPP about changes to the legislation that you brought up in the meeting, Tom. And I appreciate you doing that, Councillor Patterson, so that we have some understanding that there is a change coming to the policing services as they're being provided to us, just through legislative changes. But the actual impact to the residents right now will be the same. They'll be exactly the same service level as provided. We're investigating whether or not we can increase that or whether we'd have to go to another option. And so because that's not been presented to us, it'll be a longer discussion than something we could do in the next 10 minutes. And so we're waiting for further information from the OPP. The other item is something that the Deputy Mayor has brought up, and that is, so we discussed that about having a report from the County of Simcoe in regards to affordable housing. That has yet to be presented to us. As we mentioned in the meeting, our affordable housing discussion is pending on the County of Simcoe availability. Certainly the County of Simcoe staff have been busy with COVID, battling, and honestly, it's just been delayed, and I'm sure that we'll still get a report. I don't expect that that'll happen between now and March even, but we will have to have a discussion with the county staff and see if we can get a special workshop session set up. So anyway, hopefully we can have that information available by the time we actually pass a municipal budget. If I can go to the treasurer, would you be looking at that for the end of March, perhaps? Or is that an April council meeting discussion, Kelly?
To your worship, the actual passing of the budget is projected for January 13th. I believe what you're meaning is the tax rate bylaw, and
Yes.
that's usually around May by the time we get all the other information in.
Yes, so we will be having a workshop session on the 13th. And then from that workshop session, we will be setting a budget for 2021. And then from that, we'll actually set the tax rates, which are influenced, as we said earlier, by the overall assessment for the entire municipality, as well as any of the unknown expenses that or revenues that may be seen by the township. So that's why it changes a little bit, just a little bit right there at the end before we actually pass the bylaw. All right, anybody else with anything further? All right, it's been a really good public session. There you go. Council will move to confirm the proceedings of this meeting. And so thank you, Treasury, for participating and helping us in. We have a bylaw to proceed to confirm. It's a recommendation be it resolved that bylaw number 20-85, being a bylaw to confirm the proceedings of the December the 7th, 2020 council meeting, be presented and read a first, second, and third time and finally passed on the 7th of December 2020. Can I have a mover and seconder on this bylaw? Mr. Broderick, Mr. McKechnie. Thank you very much. Any questions? Seeing none, I'll call a motion. All those in favor? And the bylaw carries. And we have the motion to adjourn, which is pretty significant considering it's only 4:20, what is that, 4:28? Motion to adjourn. Recommendation be it resolved that council meeting be adjourned at 4:29 p.m. A mover and seconder. That'd be Lamers and that'd be Deneen. Lamers and Deneen. All those in favor? Thank you, and that motion carries. Thank you, council. Thank you, staff, for joining us, and thank you for the public for tuning in. Council will be back on next Monday night for one of our regular council meetings, which will be our last council meeting for 2020, unless we have to call a special meeting. All the best. Have a good evening. Thank you, folks.